interests of corporate entities and their shareholders. It allows the corporation to direct political spending only to the extent that shareholders have personally decided to contribute for that specific purpose. It thus ensures that the corporation may have a voice, but one that is not subsidized unwillingly by those who may disagree with its electoral message. And there is no basis in the record for concluding that PACs are inadequate or unduly burdensome for business corporations, whatever may be true of certain ideological nonprofit corporations. Indeed, PAC requirements pale in comparison with the detailed record-keeping and accounting otherwise required of corporations and unions. The ability of corporate campaign expenditures to buy influence with federal office holders and to create the appearance of such influence buying is sadly evident in nearly every aspect of the legislative processes. This fact was recognized in the McConnell case. The brief filed in the McConnell case by me and my colleagues stated, not surprisingly, the McConnell record provided strong corroboration that corporate and union expenditures on ads that were the functional equivalent of express advocacy created the appearance of corruption. Based on that record, Judge Kohler-Catelli found that such expenditures permit corporations and labor unions to inject immense aggregations of wealth into the process. She went on to say, and radically distort the electoral landscape. She further found that candidates are acutely aware of and appreciate such expenditures and feel indebted to those who spend money to help them get elected. She concluded that the record demonstrate that candidates and parties appreciate and encourage corporations and labor unions to deploy their large aggregations of wealth into the political process, and that the record presents an appearance of corruption stemming from the dependence of office holders and parties on advertisements run by these outside groups. According to the Solicitor General's brief, the record in the McConnell case showed that federal office holders and candidates were aware of and felt indebted to corporations and unions that financed electioneering advertisements on their behalf or against their opponents. The brief further stated, the record compiled in the McConnell case indicated that corporate spending on candidate-related speech, even if conducted independent of candidates, had come to be used as a means of currying favor with and attempting to influence federal office holders. It is important for us to remember that this case does not affect solely the integrity of federal elections. The states also have a great deal at stake in this case. In a brief filed in the Citizens United case, 26 state attorneys generals wrote that the courts have repeatedly upheld these state and federal corporate electioneering restrictions from their inception. In their brief, the attorneys general wrote, this case does not concern the traditional regulation of corporate spending by state laws. Instead, it presents the application of a recent federal statute to a novel form of political campaigning through the medium of video on demand and the message of a 90-minute film. These and other political campaign innovations present an occasion to draw on state law experiments, not end them. The court cannot reach the validity of these laws under Austin without departing from its conventional approach to constitutional avoidance and as-applied review of campaign finance statutes and ignoring its cautions against facial challenges in election law generally. Austin follows a century of campaign finance law at the state and federal level, honed by 6 decades of this court's holdings. Those decisions and the state and federal laws that gave rise to and rely on them delineate a workable segregated fund requirement for corporate electioneering that is embedded in campaign laws and practice at the federal and state level. While imposing minimal burdens on corporations, the segregated fund protects the integrity of the political process from the corrupting influence of corporate executives funding political campaigns that have no proven support from the shareholders or customers whose money pays for the advocacy. The flourishing of corporate speech through PACs and continued harms of direct corporate electioneering has vindicated rather than undermined Austin's approval of segregated funds. Mr. President, it's clear that the Austin and McConnell cases were correctly decided on the merits, and those decisions remain sound today. According to the brief filed by the U.S. Solicitor General, the court in Austin held that corporations may constitutionally be prohibited from financing electoral advocacy with funds derived from business activities. That holding was correct when issued and should not be overturned now. Use of corporate treasury funds for electoral advocacy is inherently likely to corrode the political system, both by actually corrupting political office holders and by creating the appearance of corruption. Moreover, such use of corporate funds diverts shareholders' money to the support of candidates whom the shareholders may oppose. Congress' interest in preventing these pernicious consequences is compelling, and Congress has chosen a valid means of achieving it, requiring a corporation to fund its electoral advocacy through the voluntary contributions of officers and shareholders who agree with its political statements. The Solicitor General's brief further stated, corporate participation in candidate elections creates a substantial risk of corruption or the appearance thereof. Corporations can use electoral spending to curry favor with particular candidates and thus to acquire undue influence over the candidate's behavior once in office. The record in McConnell, which is by far the most extensive body of evidence ever compiled on these issues, indicated that during the period leading up to BICRA's enactment, federal office holders and candidates were aware of, felt indebted to corporations and unions that financed electioneering advertisements on their behalf or against their opponents. The nature of business corporations make corporate political activity inherently more likely than individual advocacy to cause quid pro quo corruption or the appearance of such corruption. Even minor modifications in complex legislation have great potential to benefit or burden particular companies, industries, or sectors. The economic stake of corporations in the nuances of such matters as industry-specific tax credits, subsidies, or tariffs generally dwarfs that of any set of individuals. And when those benefits can be obtained through a game of pay to play, corporations are better suited than individuals to afford the ante. Corporate managers need not assemble a coalition of the like-minded. They can draw on the firm's entire capitalization without seeking the approval of shareholders. If only businesses can afford the investment necessary to pursue rents in this way, only businesses can reap the even larger reward. And the public perception that businesses reap such rewards from legislators whom they supported and campaign creates an appearance of corruption that corrodes popular confidence in our democracy. At the heart of the Citizens United case is a critical question. Do the cherished individual rights protected by the Constitution extend in the same manner to corporations? Corporations, after all, are artificial creations of law, provided for by acts of Congress and the state legislatures, and endowed under these laws with perpetual existence, special tax status, and other privileges, all for the sole purpose of economic gain. The resolution of this question in the affirmative will have wide-ranging and unpredictable results for our legal system. For example, if the court determines that corporations have First Amendment rights, it would be logical that corporations also have Fifth Amendment rights against self-incrimination. Is a corporation endowed by its creator with inalienable rights? Just last year, the court found that the Second Amendment right to bear arms is a personal right. If the court were determined